Good morning, everyone. Welcome to today's webinar. We'll be talking about the Florida Special Legislation Session, what next, or what now, I should say. We're going to start in just about 30 seconds, give everyone an opportunity to log in. We did have close to about 500 participants that logged into today's webinar. We're going to kind of touch what happened recently, or I'd say less than 10 days ago, kind of from a 30,000-foot perspective. There were a lot of changes that were made. However, we're going to talk on the topics that we believe have impacted or will impact our association the most. So why don't we get some introductions going while we let everyone log in. So first, I'll start off here with the left side of my screen, Robert Blanche from Siegfried. If you want to say something a little bit about yourself as well as the firm.
Yeah, hi, Rafael. Thank you very much. Roberto Blanche from Siegfried Rivera, representing community associations throughout South Florida for the past 22 years. And also a repeat performer here in this circuit here with Rafael and Dan and Misha. So I appreciate being provided the opportunity and the invite to come back on the show. So thank you very much. We look forward to providing some information and insight on what has transpired as a result of the special legislative session that just passed, and getting into some of the nuances of what impact that might have with regard to the community associations that we're all involved with.
Thank you so much, Robert. It's always a pleasure to have you on. Next up, we have Misha from M2E.
Good morning, everybody. My name is Maurice Ladinovic. I'm the president and owner of M2E Consulting Engineers. We also a repeat offender on this Rafael's seminar. Thank you very much for the invite. I have been representing with my firm, Condominium Association, throughout the state for the last 35 years. I am a licensed engineer in the state of Florida and another 7 states, and also a licensed general contractor. We are a full service engineering firm, which means that all of the disciplines are performed in-house, and we specialize in the 30 now called and 40 years recertification for condominiums as well. Looking forward to contribute to the panel. Thank you again for the invite.
No problem, Misha. Always a pleasure to have you on as well. And last but not least, Dan Odess with GlobalPro.
Thank you all. And yes, definitely. It's great to see all of your faces and to do this. We broke 200 there already, participants. So this is going to be an exciting panel. Obviously, a lot of attention on a lot of things. GlobalPro, founded in 2012. We're in our 10th year here, celebrating our representation of policyholders, whether it's placing insurance or covering from loss. We've managed more than $1 billion in recovery and thousands of policy placements throughout the country. We are a full service company and our expertise and our licensing expands not from anything from being an adjuster to an attorney, engineers, contractors, all there to help and support you with your insurance needs.
Great. Thank you so much, Dan. Always a pleasure to have you on as well. As for myself, my name is Rafael Aquino. I'm the CEO and co-founder of Affinity Management Services, a boutique community association management company servicing Dade, Broward, and Palm Beach County. Thank you all for being here. I did put up a poll. It's great to see that we have a pretty good mix of managers as well as board members in today's attendance. Today, as mentioned earlier, we're going to be going over what happened at the special session. There were many things that happened pretty much within less than 48 hours that many of us did not expect. I mean, this special session was initially done to help out homeowners insurances, and what we received was something totally different. And I'll let Dan go into the insurance in a little bit. But I think it's best to start off with Robert to give us a high level of what the bill has, what was proposed, or what I should say, what was passed, and give us kind of like a 30,000 foot of what's going to impact our condo associations.
Sure. You know, in a very concise nutshell, the bill that was adopted by the legislature, known as Bill 4D, provided mainly 2 new components with regard to community associations. And this, of course, is no surprise to, well, I think it was a little bit of a surprise to some of us in the sense that the legislature adopted this in light of the fact that at the regular session, they did not adopt any of the legislation we were all expecting that they were going to adopt following the, catastrophe and tragedy over at Surfside. But in this legislative session, the legislators did apparently make good on the promises that had been made for the adoption of new legislation to provide for what they have been marketing as making buildings safer. And so they've done a few things. The main things they did is they now require, starting in December of 2024, every building needs to have and undergo what is called a mandatory structural inspection or a milestone inspection at the 30 years of age or at 25 years of age if the building is located within, I believe it is 3 miles from the coastline. And so these milestone inspections are similar to what we in Dade County and Broward are used to as the 40-year recertification. It's a similar type concept. And of course, Misha, I presume we'll get into the nuances of what the actual inspections are going to entail. And in very simplified terms, the first phase is for an engineer or an architect to come into the building, take a look visually at a very cursory review and how detailed they need to do that inspection. Misha will get into, and that is the phase 1 report. If there merits getting into a more invasive or destructive or detailed inspection of the building, that will be known as the phase 2. And Misha again can get into some of those details. This study is supposed to be repeated every 10 years after the initial one is required. For buildings that have COs from July of 1992 or before, they're going to have their studies done by December 31st of 2024. So that's something to keep in mind. The other component of the bill was the establishment of what is now known as the Structural Integrity Reserve Study. So all buildings, we know that every budget for every condominium building and co-op must have reserves. And in order to determine what amount of reserves to include in your budget, you should have some type of reserve study, presumably prepared by somebody who knows what they're doing as far as determining the remaining useful life of mandatory reserve components and how much the estimated replacement or deferred maintenance costs are going to be for those components. We also know that historically, boards had the option of providing members in condos and co-ops with the opportunity, if they so chose, to waive or reduce the funding of reserves. Well, what the legislature has done now by establishing the requirement for structural integrity reserve studies is, number one, they're requiring that a study be performed, first and foremost. And secondly, this reserve study is to be performed for a category of 10 enumerated items or categories of building components. And these are provided in the statute as to what those 10 components are supposed to be. And buildings, condos, and co-ops are going to be obligated to reserve for the items within that structural integrity reserve study. And there's going to be no opportunity for waiver or reduced funding of those enumerated building components. And in fact, the statute even, the bill goes even further in establishing personal liability for directors that do not comply with the obligation to perform structural integrity reserve studies or milestone inspections. And the way that the legislature has done that is that they've implemented provisions that say that if the association board members do not comply with the requirements for these studies or inspections, that is deemed a breach of fiduciary duty of those board members, which presumably the objective of that is to have the directors have some personal skin in this process and potentially risk personal liability if they don't comply with this. So the legislature has upped the ante somewhat by virtue of now making directors potentially personally liable if they fail to comply with these obligations. So I don't want to get lost in the weeds too much more, but that is a very general overview as to the two main components of what results from this bill.
Robbie, could you just define minor buildings versus other buildings? I think that's the language that everybody wants to hear.
Yeah, so the statutes do draw a distinction with regard to buildings that are below 3 stories and above 3 stories. So buildings that are 3 stories and up would have to comply with these requirements, and those that are below 3 stories are exempt. And then there's also some other exemptions with regard to the number of units in the building. I believe it's a building with 2 or less units, you're exempt, and we can get into the statute as to what is in there. But suffice it to say that most of the condominiums in our general market area will be required by virtue of just being above 3 stories to comply with these requirements.
Excellent. Thank you, Robert. And obviously with what you stated, I mean, going into some numbers here that I wanted to provide to our listeners, based on the Florida Bar Task Report, you're looking at about 16,000, approximately 500 units that are at least 30 years or older, which will require some kind of milestone inspection. So if you base it on unit count, it gets even more concerning. It'll be close to almost 60% of all the units in the state of Florida will require this milestone report. So Misha, I want to chime you in here because I know that there's been many questions of what's the milestone report, the phase 1, and then when is it going to move into 2? So I guess if you could give our listeners an understanding of what your firm is doing or how you're preparing for this, and how do you believe that this is all going to be rolled out?
Thank you. Yes, by all means. For those who live in Broward and Dade County, Miami-Dade County, this is really nothing new. And I'm going to address that because it's the simpler of the two answers. Imagine that you're going to have to do your 40 years of certification at 30 or 25 years. However, the requirements of the reporting within the 40 years or now 30 and 25-year research have changed. The scope of what needs to be reported on now includes building components that were not included in the previous guidelines. Examples of that will be expansion joints, particularly at pool decks, glazing systems that are part of the envelope of the building, and such. Therefore, you will have to have somebody who is versed in these particular components to opine on them, because they will have to assure the integrity and functionality of those components. Number two, the licensing of the people required to do these inspections has been changed by the legislature. You were able to do these things by any kind of engineer, and today the word of the legislature is that structural engineers are the one that can only certify the structural components, and electrical engineers are the ones that are certifying the electrical components. In addition to that, for threshold buildings, which are mid to high rises, they will require that structural engineer to be also a threshold inspector, which is a special annotation in the structural engineer world. So the requirement of the licensing of the people producing those quote unquote milestone report or a certification report will be different. What is a milestone report is essentially a snapshot on the integrity of the building. So if you would look at what the paperwork was that we used to submit in Miami-Dade and Broward County, plus the additional components that we just talked about, that's what it is. In addition, the risk of hiring an engineer that is not versed in that, because he or she will have also to prove that they have experience in buildings of this complexity and size, is that if he certifies a building to be safe, and eventually either a peer of his or a component that he certified safe fails, he, that engineer, is liable and can be punished with $1,000 fine plus a complaint to the boards of certification of engineers, which means that he will likely have his license in question. Looking at the verbiage and why it was put there, I wouldn't want to be that first engineer that gets his report questioned. So there will be a disciplinary component where it was not going to be just an engineer say, nah, it's okay, and move on. So that's far as what are milestone inspections. What is phase 1 versus phase 2? What the legislature has outlined is that the first inspection is a visual inspection. And you essentially will have a professional that will look at your building, and based on the visual inspection, he or she could, if he or she is satisfied, certify the building as safe. That's where the milestone inspection stops. Remember, he or she will have to certify without any further investigation all of the components that I just mentioned, or risk the possibility of having his license yanked up if in fact those components are not performing as they should be. The more likely scenario, based on what we see typically in the field, is that further investigation will be required, because even if there is failure of certain components, we really don't know how bad it is until we look at it in depth. If in fact a more detailed inspection would be required, that would be the phase 2, where that inspection would actually look at all of those components, estimate how suitable they are for the intended use, what type of repair needs to be performed, and by whom. That's kind of the 50-second executive summary.
No, that's perfect, Misha. And I mean, from your understanding, or from your opinion, I guess I should ask, and I know we were talking about it a little bit offline prior to getting on the webinar. What's your opinion of reputable engineers of really signing off on that milestone report? Because with everything that has occurred, and everyone has read, the payouts that were done there at Champlain Tower and so forth. Do you believe that most buildings and most engineers are going to sign off on that first milestone report?
No, I don't, because we are good, but we're not Superman. Hence, we don't have X-ray vision. I don't know the health of rebar. If I see localized spalling, which is the separation of certain chunks of concrete, I don't know whether the rebar is only rusted in that spot or it's going deeper. So you would need to inspect that better. If there is a spot leaking of an expansion joint in a parking garage under a pool deck, it can be just that spot, or it can be that the entire waterproofing of the upper deck is failed. I don't know. I don't foresee that a lot of reputable and, more importantly, insured engineers would do that, nor would their insurance endorse that. We already got calls from our insurance carrier asking whether we're going to do this kind of inspections.
Yeah. I mean, I'm sure with everything that has occurred, I mean, in our experience, especially with what we've been hearing, different conversations that we've been having with different partner and providers, I should say, we've been hearing the same thing, that, most buildings, again, there are buildings that have done their part and have maintained their associations the way they need to maintain them, or they've just done their recertification. So that's going to be a totally different game. But speaking of the majority, when you're talking about 16,000 plus associations, many of them, especially outside of Dade and Broward County, which that was a great example that you gave, that have never really done much, there's going to be some major impacts when it comes to this. And how we're going to manage these impacts, it's going to be interesting, because as we were stating offline before, the costs are definitely going to increase. Recently, I was talking to a board of, advising them that some preparation needs to be done. And, first thing that was said as well, we don't believe that this is going to remain, that there are going to be some changes. It actually brought chills up my back, because I don't personally believe that there's going to be much change when it comes especially to the reserve portion of it, and the building component of it. I did want to highlight some of we're getting many questions here with regards to what are the components for the structural integrity. And the components are the roof, load-bearing walls, floor, foundation, fireproofing and fire protection, plumbing, electrical systems, waterproofing, exterior paint, windows, and anything that negatively affects the items that we listed that have a value of over $10,000. So when you look at that, based on my experience, that's pretty much a bulk of what you're reserving for. So many associations are going to need to start preparing now. Again, just trying to push this off, saying that our legislators are going to make some changes and that we'll deal with this later down the line. I'm of the opinion that it's definitely not the right time to do that. Now is the time to at least start preparing and understanding where you're going to go with this. So I want to bring Dan. Yes, go ahead.
I just want to say that the way that you approach the actual property condition assessment or milestone is part of the know-how. When we do these things, what we do is we essentially schedule over time thing that needs to be done. So it's not only here is this, spend $10 and everything is going to be fine. We are sensitive to the fact that this is going to be, particularly in counties that are not Dade and Broward, put in the lap of association boards that were not ready for this. And their typical answer is going to be, but I don't have the money for it. The way that the law has been written is that there is flexibility, and just to repeat part of the discussion that we had just when we started this, and I'll shut up after that, is the point is that there is a provision that as long as the engineer certifies the safety of the building every 6 months, you can continue doing the repairs as long as the engineer say that while doing the repairs, the building is safe. So the way that we see it and the way that we do it typically is you need to spend $10, but you need to spend $2 right now. Then you need to spend another $3 by the end of the year. Then you need to spend another $2 down the road and $1 every year thereafter. And therefore that will be fine. Building departments are not in the business of closing buildings. There is a provision in this law where they can cut the power to the building if the building doesn't comply. And the point is that that's not what they want to do. What they want to do is to get the building to comply so it's safe to be occupied and that the building units with their value contribute to the real estate value of the community. That's it. So as long as you have an engineer who knows what he's doing or she's doing, by telling you, this is everything you need to do, and we understand that right now you can raise only X amount. By the time you get your financing from the bank or insurance or otherwise, this is how we'll stagger it, and it's going to be a 3-year project. But board number 2 next year cannot stop the project because I'll stop certifying it the moment that you don't stop doing it, and the city will call you on it.
Yeah, so basically you better get moving.
Yeah.
So Dan, I want to bring you into the conversation, and we have 15% of the listeners mentioned that they want information on insurance, and obviously this special session was brought together for the impacts or the challenges that many of our homeowners were having with insurance, and this turned into totally something else, even though there were changes on insurance. So maybe if you could give us a kind of like a high level of what changes you agree with, or what changes you wanted to see that didn't happen.
Well, I mean, generally speaking, insurance is all about trends, right? So the insurance companies, through their actuaries, the bean counters, if you will, are supposed to be projecting changes in the market, whether that's weather, whether that's construction, recessions, things like that, are supposed to be anticipating those things as they change. The idea that this special session was to address a troubled insurance market in Florida sounded great. And I'm sure it did motivate a lot of people to speak up about why they thought the issues were what they thought the issues were that were plaguing the insurance market. And even the governor wrote in a special order that addresses homeowners insurance, ironically, and no surprise to us, that are on the policyholder side, that are advocating for them. We find that much of the legislation shifts burden onto the policyholder, not onto the insurers, and holding them more accountable, and strips policies of more coverage. And as those that even voted for this legislation overwhelmingly will say that they do not expect to see any sort of reductions in the cost of insurance for at least the next 18 months, I would actually say ever, because since 2011 and 10, when some of the most anti-consumer legislation for insurance started to be passed, and there was this aggressive lobbying effort by insurance companies, and you can go look at the numbers yourself, we haven't seen any positive impact that any sort of the legislation or changes that have been made to, the cost of insurance. And there's been very little on the side of accountability and reporting. Even in Senate Bill 76, that was just passed just in the prior session, that was supposed to address some of and make the insurers accountable by forcing them to actually report on issues. When asked about that reporting, which was supposed to occur in January this year, some of the legislators who proposed that legislation last year said, well, there's some confusion over when that reporting was supposed to happen. Well, a lot of that reporting had to do with the cost of claims, the actual cost of the claims, not just figuratively speaking or projections, which is what was used as a basis to rally around all this anti-consumer stuff. So when questioned about it, they blew it off and said, oh, no, that we're not going to start that until 2023. There's no construct for the Office of Insurance to actually review and collect that information yet. Well, you passed that last year. So they passed even more legislation, allegedly, that's going to hold insurance companies accountable and increase reporting standards, et cetera, et cetera. So overall, generally speaking, you have a lot of anti-consumer legislation passed. It's not going to do very little of anything to help consumers. In fact, for community associations, which is what this topic is about, understand that while the order signed by the governor was to address homeowners insurance market, there were broad sweeping changes to insurance as a whole. I think some of the biggest changes I think that were in the bill is an issue regarding a requirement for the insurers to produce records as it relates to the adjustment of claims. That was something positive. Upon a request by an insurer to do something, they have to submit reports. As far as relates to assignment of benefits, if we've heard it, I'm sure it's been played out in the media a lot. Assignment of benefits is a tough one. Most contractors operate under an AOB, or assignment of benefit, where the association will assign their benefits under that policy to them, with this idea that they will be, quote unquote, directly paid by the insurance company. Now, those AOBs of the past, and I say past because they've changed, allowed the contractor to sue your insurer if they were in a disagreement. What it's done is it's stripped the legal fee opportunity for the contractor. They can no longer recover those attorney's fees if they were to sue your insurer if the insurer disagrees. Now, why that's important is because if your contractor does not get paid for their work, they are going to be looking to you to get paid for that work and be looking to you, the association, to file that lawsuit. And you'll be stuck in a rock and a hard place because your building will get liened. They will sue you, and you'll be forced to then sue your insurer or make amends with that contractor at a loss. And why this is incredibly important is that there's less adjusters today in the market working on behalf of insurance companies than we've ever seen for these losses. And there's more consultants being used. It's like the battle of the experts on every claim, even the small ones. And one of the things that they're attacking most are the costs of the work by mitigation contractors. And while insurance companies largely own and operate the estimating software that's used to put together these invoices or proposals by these contractors who are doing the mitigation work, most of the consultants have shifted away from it to using their quote unquote proprietary systems, which again is undercutting and creating a lot of disputes and issues, leading to a lot of this litigation. And I can tell you that more often, almost always, do the insurance companies pay more than what their consultant write? Even if you don't go to litigation, it just creates a dispute, creates an issue, creates friction between an association and a contractor. This is increasingly more important since we're in storm season. We just saw a storm. We just saw an amazing amount of flooding in South Florida. You had a lot of mitigation contractors out there, but that wasn't even a hurricane, right? That was a major rain event, basically. You bring in a hurricane and you have winds and damage, and you have contractors coming in from out of state and everything else. They have different billing practices into these local markets. Your only option as an association is to hire some of these companies because the local guys are basically maxed out. And it's going to result in a lot of disputes, a lot of issues. And unfortunately, a lot of lawsuits against the consumer again. So they've redirected, right? They've directed again away from them onto the consumer. The consumer now is responsible for these things, strip them of those rights to do those things, which were fluid process. Did not report on the actual issues that they were supposed to report under Senate Bill 76, which they rather used projections from the industry, the insurance companies themselves on some of these things, rather than actual data from the insurers. And here we are. And one of the trends I started off with this, and I'll throw it back to you, Rafael, is there's been a change with regards to roof deductibles for homeowners. Now, we've already started to see sneaky little limitations and deductibles into insurance policy. I'm sure many of you tuning in today probably have $25,000, $50,000, $100,000 water deductibles. You have no mold coverage anymore. You have higher than average deductibles on wind. I say on average because we've actually done the analysis here in the office. We represent thousands of associations, so we have a pretty good sample size. And now you're seeing a trend towards offering some sort of reduction or more deductibles, more limitations. And we're not going to see rate reductions. We're going to see rates continue to steadily increase, right? So we're going to see steadily increase. We're seeing additional more and more deductibles placed there. It's a troubling situation. I don't believe they got the job done. We need more accountability. And I honestly think it's, some of the changes we saw on the homeowner side were revisions to the My Safe Floor homeowners. It's kind of similar to some of the changes you're seeing with these building inspections and community associations. So again, when I talk about trends, you're seeing these trends percolate through all of this issues, and they're all somewhat interrelated. So if it's happening with homeowners, believe you, on some of these surplus lines insurers who use some old archaic forms and endorse and do everything else, they're probably going to try to start doing some of the sneakier other things and offer you some sort of reduction for it. But be careful. How are you going to reserve for that stuff? How are you going to estimate what that may be if something were to happen? It's almost near impossible. That's why you have insurance. But we're having to be mad scientists over here because their coverage is being stripped. These publicly traded companies are reporting billions in profits, and they're stripping the sword that you wield, your contractor or even you have against them by limiting attorney's fees, limiting your access to consumer advocates. And so I can tell you the analysis done on the bill by industry advocates called Florida Association of Public Insurance Adjusting is over 100 pages. It's much longer than the actual bills themselves. There's many conflicts. There were questions about those conflicts. One of the Senator Pizzo, it was now become almost like famous for saying it. In this roof repair thing. If I have a 1-year-old roof, new roof, I have a damage in 5 years and then a damage again. How old is my roof? Because then you got to figure out what the deductible is. And then Senator Boyd, who basically drafted this bill, says, well, that's something we'll have to consider and think about. They don't even know how to actually determine what it is or how this stuff is going to apply. But man, they got their job done. They signed the bill and it's been passed. So.
Yeah, I would agree with you. The way that it went down wasn't necessary. I mean, change was needed for our industry. There's no doubt. I'm totally for the reserves. It makes our lives as managers, and I'm sure 30% of the managers that are on our call today would agree with me that an association with funds and monies available, it's much easier to manage because the decision isn't as difficult of, well, how much of a special assessment do we have to pass? How much do we need to borrow? However, how it all went down, all rushed, not understanding how this is going to play out, it's going to make our lives much more challenging now. We do have 2 more years to hopefully get things cleaned up, but in the interim, we need to continue moving forward as if nothing was going to change. So Robbie, I wanted to kind of bring you back in here. You had mentioned in your intro about the potential issues that board members can have if they don't do the structural integrity reserves. What kind of liabilities could a board be looking at? And do you believe that, their D&O coverage, someone asked here, would come into play if they decided just to, I'm not going to do this reserve, structural integrity reserve that's being required of me?
Yes. I've been taking a look at some of the questions that have been asked, and I've made an attempt to respond to some of them. The statute says that if you do not, for instance, under the mandatory milestone inspection, it says if the officers or directors of an association willfully and knowingly fail to have a milestone inspection performed pursuant to section 553-899, such failure is a breach of the officers and directors' fiduciary relationship to the unit owners under section 718.111(1)(a). Similarly, when it addresses the structural integrity reserve study, and I'm going to try to find that section while I speak, there is comparable language as to the potential liability. Here it is. It says, if an association fails to complete a structural integrity reserve study pursuant to this paragraph, such failure is a breach of an officer's and director's fiduciary relationship to the unit owners under 718.111(1). So what this means is, if you fail to do it, if you knowingly, as a director, if you knowingly or willfully fail to have a milestone inspection, then you've breached your fiduciary duty. There is no mental threshold requirement as a director in the event that you fail to have, or if your association fails to have, a required structural integrity reserve study. And both of those failures, knowingly and willfully for the milestone inspection, or just a simple failure for the SIRS, the Structural Integrity Reserve Study, render you as a director and officer to be in breach of your fiduciary responsibility that is owed to the association. You need to carefully review the language of your D&O policy, and you need to sit down with your insurance agents that are selling you those D&O policies to see what your risk is with regard to whether or not you're going to be covered by that. It's my understanding, though I'm not an insurance expert and definitely not a D&O insurance expert, it's my understanding that you may run the risk of not being covered because statutorily you are now deemed to be in violation of your fiduciary duty. But again, the proof or the correct answer is dependent upon what needs to be included, or what is included rather in the policy, in the D&O policy. So.
Okay, excellent. I do have several questions here when it comes to some of the guest managers or board members. Is they're asking, does this new law apply to HOAs or just condos?
This applies to condos and co-ops, not to HOAs.
Okay, and I do want to provide a verification because someone brought it up here. The milestone inspection reports, if your building falls within what the law requires, which is 3 stories or higher, depending on the age, it is going to need to be completed by the 31st of 2024 as of now. And the same thing goes with the structural integrity reserves. Misha, I wanted to bring it back to you. I know, again, we're always looking at it from a management side of how we can try to save our association some money. You know, over the years, it's been common for us to do reserve studies, or for us to get, a reserve study specialist to do these reserve studies for our associations. However, a lot has changed now that those components, those 10 components must be done by an engineer. I've mentioned it at another, with different conversations that I have with both board members and vendors, of potentially combining the milestone report with the reserve study, since the engineer is going to be there, and try to be a bit more cost effective. What's your opinion on doing that? Is that something that you believe is doable, or is that something that you believe is going to need to be remain separated?
There is, I think that we're all now living with a new reality, and I think that in my mind I would separate the reserves themselves, and within the reserves what we would call structural component, so as not to duplicate the work. I would rely during the milestone inspection on the structural engineer / electrical engineer to actually give you the scope, an estimate of what needs to be done for structural integrity purposes. Then I would plug that with all of the paint and other stuff that are part of the rest of the reserve studies. So those components that the engineer would inspect while he's doing his milestone inspection, I would rely on what that scope is in order to prepare the structural integrity reserve portion.
Okay.
And then
Excellent.
that
Yeah.
can be integrated in the rest.
Yeah, that would make sense because it would be able to definitely help with costs. I know we have many questions here, and we've had it already with some of our current clients of how are we going to fund this? Because, so again, as we said earlier, especially those associations that don't have any reserves, that have spent years and years waiving reserves. I think you had a good analogy, which if you don't mind sharing it, Misha, that you explained the difference of the new car. I think I don't want to botch up your analogy, so maybe if you can
So,
chime in and
yeah.
give that analogy, I think would be great.
Well, the point is that if the building was actually maintained over the 40 years the way it should have been maintained, the 40 years or certification should not be a dramatic event, or the 30 years, or particularly not the 25 years. What has happened is that if the building were left in disrepair just because nobody wanted to spend the money in maintaining them properly, a building is a live thing. It's no different than a body or a car. So you not maintaining the building is essentially driving a car for 50,000 miles, not changing the tires, not changing the brakes, not changing the oil, counting on the fact that you're going to sell the car at 50,000 miles plus 1 mile. And that becomes the problem of whoever buys the car from you. Except if you actually continue to own it past 50,000 miles plus 1, and you go to your service mechanic, the mechanic goes, you never changed the oil in this sucker. I need to rebuild your engine rather than just changing the oil. And then you go, what do you mean rebuild the engine? The car was working perfectly until yesterday. And he goes, what do you mean you didn't change the oil? So if the choice was not to maintain the building as it should have, which would include painting, stucco, regular inspection as far as maintaining the structural integrity of the envelope and the structure, then obviously that's the equivalent of your body. If you only eat sugar and junk food and don't exercise and come to the doctor after 25 years, he goes like, you are beyond diet, my friend. I need to put you either in operation or something more, and it's going to cost you. Why is it going to cost me? It's because you didn't exercise and didn't eat properly. We can go on with parallels, but the bottom line is that a building is a live thing, and if the choice was not to maintain it for 40 years or 30 years, then the bill is going to be steeper than if it was properly maintained. That doesn't mean that it is not feasible, and this is the second part of it. Again, building departments are not in the business of cutting power and putting people on the street. There is a way, a dosage, if you want, of necessary repairs that need to happen, unless the building is truly in disrepair. But let's eliminate that for a second. Assuming that the building can be put into a safe condition by having X amount of funds, then that's what you spend immediately. But then there is a plan of how you're going to make the building compliant over time. And that plan is part of, and should be the part of, what the scope that is defined by the engineer doing the inspection.
Good point. I honestly love that analogy. It nails it right on the head. And Robert, sticking to the structural integrity reserves, because I know that's a big concern for many board members and managers, because that's going to financially impact them significantly. Is it your interpretation that with the separation of the two, that the structural integrity portion will be allowed to be pooled? Or what's your opinion there?
You know, the way the statutes are drafted, the provision that pertains to structural integrity reserve studies is included in the section that addresses what required reserves are to be included in your budget. 718, 112, 2F2, for instance, in condominiums. And when you read section 61B-22.005 of the Florida Administrative Code, it is the provision that addresses whether associations may provide reserves to be accounted for either under the straight line method or the pooled method. And in this section of the Administrative Code, it tells you that you can have reserves accounted for either pooled or straight line. It doesn't distinguish whether they are structural integrity reserve study reserves, or if they are the other types of the, let's call them the traditional reserves. Mm-hmm. So conceivably, it appears that you could still account for them under the pooled reserve accounting method. Now, practically speaking, I don't know how that or whether that's going to be feasible. And I think we're going to need to, I think next time we invite a fifth panelist here, which is an accountant, because I do believe that our community association accountants, we're going to have a sit down with them to see, practically speaking, how, if at all, we're going to be able to account for these SIRS reserves within the pooled line method.
And that's a great point that you bring that up, Robert, because our director here, which is a CPA, she's actually trying to figure out, okay, if we're going to need to separate these, we're of the opinion that we would want to continue with a pooled method for both. And reason being is because, again, sometimes costs go up and so forth. It makes it much easier for us as well. But that's a good point that you bring up. We're still figuring out how our software, how we'll be able to break it down into two different, I guess, buckets, if you want to call it. Dan, I want to bring you back into the conversation here. China brings up a great question. I've had this question for myself as well, as will the condos see any relief with these high premiums now that, we're going to have these kinds of inspections, potentially, the long-term objective of this is that buildings are properly maintained. I know you can't say the exact answer, but at least what's your opinion? Do you think they'll see any relief in the coming years now that buildings will quote unquote be more structurally sound and safe?
Having done this for over a decade now, and having seen major overhaul changes in the building code, I am a licensed general contractor as well as a licensed adjuster and an insurance agent. Been through engineering school. I've done high-rise construction, worked through turnovers. Part of our process, and we have the signature process, Ready to Recover Build, is talking to associations about what to do with money from proceeds and how you may be able to reinvest that money back into the property for cost mitigation with regards to insurance. And I've campaigned on this for so many years. So, the silver lining is that while a lot of associations are, groveling over the reserves and everything else, totally understandable. It's a big change, talking lots of money here. From one day to the next, our lives are changing financially. However, a long-term perspective of this, I think can result in a lot of positive change. So as long as the legislature and takes note of it when they're passing these laws and reforms and particularly on accountability. There are ways to measure the impacts of mitigation efforts. Loss mitigation efforts is what they're typically called. Or you'll hear another insurance term called protective safeguards. Mm-hmm. There's a way to use those in campaigning and marketing your building to an insurer. But your broker needs to understand what those things mean and why you're at an advantage for having them. Certain types of mitigation programs, they used to give you discounts if you signed up with a mitigation company before a storm season or whatever else. I'm not really seeing that anymore. Because they've taken the campaign on the road to fight the mitigation companies at this point. They're not so interested in you engaging one ahead of time. But there are so many things you can do when you're, considering, the pool furniture versus the next upgrade on windows to go to a better window or a better balcony system, or a repair versus a replacement of a concrete area. Maybe you went a little bit more on a preventative reason. Start to take note of these things, start to highlight those things, start to involve those in the conversations, and participate even after you've gotten an appraisal. Look very closely at those insurance appraisals. Many times they're not taking into account a lot of the loss mitigation efforts by an association ahead of storm season or prior to a renewal. So really, certainly take really close look at that. It once used to be that if you were properly reserved and could demonstrate that you were the best candidate for insurance, and you would be afforded some better rating. Obviously part of consideration, but we're seeing a lot of effort by brokers and campaigning this idea that somehow condo associations that suffer property damage losses are uninsurable or it's going to cost them more. You have to separate property insurance from the other lines of insurance, liability insurance, as well as your D&O insurance. One of the silver linings on the AOB thing that I brought up earlier with regards to assignment of benefit with regards to attorney's fees is that there was this rampant by insurance companies suing on behalf of homeowner insurers and for HO6 policies that were sold to unit owners. They were then turning around and filing lawsuits through subrogation against associations, even if there wasn't coverage. And the laws in the past couple of years changed that and curbed it. So when I look at these numbers as it reports to insurance litigation, what they're not also bifurcating is the litigation by subrogation counsel for other insurance companies that are selling homeowners insurance that are suing these surplus lines insurers rampantly, so much so that the legislator passed laws to curb it. So you curb that. You've now stripped AOB. We're going to upgrade our buildings sooner rather than later. We're going to be doing all these things, doing inspections. However, on the flip side of it, you got to be careful with what's in those reports, right? Because while it may help you in fortifying and going through loss mitigation efforts or this idea that we have a better building than we did yesterday, there may be things in there that may actually be used against you in the illegal practice of post-loss underwriting, which we do see a lot of insurers engage in, particularly after hurricanes. You see these massive document requests where they want to review every record from here to, the last 25 years of association to figure out whether or not they owe you the money, even though they didn't do any of that when they sold you the insurance, when they collected your premium payments. So just be careful. And it may be part of the interview process with your engineering firm have they ever been engaged and involved in any insurance claims? Are they considering that when what language they're using or inserting into those inspection reports? A lot of your engineers may shy away from those types of questions. We do participate in a lot of, upfront loss mitigation efforts. When you are doing these inspection reports, there was a question that came in earlier. Will insurance companies help offset these expenses? A lot of people don't realize when you have that first notice of a structural issue, most often you can obtain coverage for damage to concrete, falling concrete, various other structural deficiencies that lead to damage, or you have suing damage to a property, you have water getting into somewhere. We do often handle hundreds of those types of claims. So there is coverage for some of this. If, the circumstances and issue and history and all of it line up, but it's not without, and I did respond to the question and offered that in the chat there. So I know there's a little bit of confusion between the chat and the Q&A. So we're getting questions in both areas there. But I cut and pasted it, something to consider, something to think about. Some of this stuff, the legislation is a little bit of a double-edged sword. I think it's going to help on the liability insurance company side, but on the flip side of it, I definitely think we're going to see some friction between the mitigation company and the associations. However, when you're going through these inspections, consider it, look at it, but also think about, I think everyone needs a longer view of these things. And I think for some largely investor-owned associations, I think a lot of them are probably going to struggle a little bit more with a longer view of it than some of the others who live with a full-time building, or the majority are there. I think they'll consider those things 10, 20 years down the road. What is it going to mean for me? And can I do something now to help mitigate that cost?
Yeah, I'm hoping, fingers crossed, but that there is going to be some change with all these improvements that are going to be placed in these buildings. But again, we can't hold our breath. Misha, we've had many questions here when it comes to many of these buildings that had inspections done right after the tragedy at Champlain, or they just wrapped up their 30-40 year recertification, and the question is, am I going to have to redo this milestone report again? Am I going to have to go through this entire process again? And just wanted to get your opinion on that.
My read is that as long as that inspection was significantly in conformance with what used to be the 40 years research, if you want to call it, that will be, just continue doing what you're doing, file your 40 years research, and you'll be fine for the next 10 years. But if you just got a letter from Peter, Paul, and Mary engineers that says, you're okay, no, that's not going to cut it. So the key is, if you did what was expected from you to do, and you did it right with the right engineers, and he or she certified that all repairs were done, and therefore she certifies the structural integrity of the building. We actually had on a building that we did the 40 years research in Miami to write a letter of certification of structural integrity, which was fine because the repairs were done per our specification. So as long as at the end of that process, there is a letter stipulating to the structural integrity and the functionality of the building, I think that they are fine for the next 10 years.
Excellent.
Same if they're doing the 50 years. I had one answer also. What about 50? Same thing. If they did the 50 years, they did it in an appropriate way. The authority having jurisdiction might require the same letter from their engineer, which is fine because it should be fine. And they are fine for the next 10 years.
That's going to bring a lot of relief to many board members and managers, I'm sure. But as we've mentioned multiple times, if there ever a time to make sure you're working with the right individuals, I would say it's now. We're going to find that there's going to be a flood of engineers that probably haven't been into our sector of community association management, that don't really understand what it is with the components and so forth. So if there's ever a time to work with an industry expert, I say it's now for both the managers and the board members that are on the call. As Misha had mentioned, I think that this is going to be very serious, especially for the counties or municipalities, wherever your condo association is located. And as we wrap up here, I've had a couple questions, Robbie, when it comes to the actual bill. What's the bill that was actually approved by Governor DeSantis? And the other question that maybe you could do two with one is this actual law already? There's some people here, I guess, that don't understand if this actual law yet. You're on mute, Robbie.
The bill was signed into, well, let me not say it was signed into law. It was approved by both houses. It provides for, let me confirm here, the effective date or what the status is with regard to the, give me a few minutes and I'll provide you with
sure, no problem. I also have another question here that's being asked you, and I'll go ahead and answer this one, is when it comes to the structural integrity reserve, what's the deadline? Again, if your building is 3 stories or higher, you are going to be required to do that structural integrity reserve study. The date as of now is March, where did I get that from? It's December 31st of 2024. So what that means is that you need to start having the conversations already with your partners, whether it be M2E. It should be a firm, again, that's specialized within our industry, that understands your building's components, so that you can get yourself on their schedule and be able to get this done when it needs to get done. If there's ever a year that's going to be challenging for our associations, for those that don't have reserves, it's this year. Managers, for those of you that are here, I believe it's about 35% of our participants today are managers. You can't have a fear of not proposing reserves if you don't have reserves. Whether you have that structural integrity or a regular reserve study, this is a year that you need to be open and honest with your clients and let them know what's coming. If you haven't shared the information with them, make sure that you share this information with them and let them know what's to come. We will be posting this video on our YouTube page, and I'm sure all the partners here will do the same. So just have them either attend the webinar or, view the video and get an understanding of what's to come. So I think Robbie has here the bill and the date that it was signed.
Yeah, it becomes effective upon, the effective date is upon it becoming a law, and it has been approved by the governor. So it is effective. The deadlines we've been discussing, mainly speaking, the December 31st, 2024 deadlines are the very critical ones. Again, that doesn't mean that you don't have to comply until that date. What that means is, for instance, your SIRS, your Structural Integrity Reserve Study, will have to be completed no later than December 31st, 2024. That reserve study, assuming you wait till the last minute, that reserve study will then tell you what your required reserves are going to be for those 10 items. And so that reserve study will become part of the budget that goes into effect after December 31st, 2024. So let's call it the 25 fiscal year budget probably. And during that year, you're going to have to fund reserves. Therefore, if you wait till the last minute, it's going to be a tough pill to swallow to start funding reserves pursuant to that reserve study. With regard to the milestone inspection, the critical date will be when you got your CO. And so you might need to get your milestone inspection before that. It will depend on the 30-year or the 25 years, or alternatively, it may depend, for instance, on whether or not your building had a CO before July 1st of 1992, because if you did have it before July 1st of 1992, then you will need to have your milestone inspection before 12/31 of 24. So I guess given the fact that we've got a whole bunch of convoluted deadlines and very complicated head-spinning deadlines, both with regard to the SIRS reserves and with regard to the milestone inspections, and whether you're a 25-year, whether you're a 30-year, whether you're a building that was CO'd back in 1992 or earlier, I think the safe bet here is to reach out to your association lawyer, have them give you an opinion exactly as it relates to your particular building, when it is that you need to have your SIRS done, when it is you need to have your milestone inspection done. If you had a 40-year or a 50-year or one of those other type of inspections or recertifications that fell under the Miami-Dade or Broward County ordinances, do you need to redo this, as Misha indicated? All of those answers, you should get those answers directly from your attorney as it relates to your particular building, because the answers may vary.
Excellent. Thank you so much for that clarification, Robbie. And Misha, it looks like you have a point you want to
I
address.
just have one thing that I think it's a Robbie question more than a Misha, because there was repeat question. What happened if the windows are based on condo docs, unit owners' responsibility? Does that mean that the HOA now is in charge of enforcing them to take care of them? Because glazing is part of the mandated requirements now. Do you have an opinion on that?
Again, that's going to be a document specific question, Misha, because, for instance, there are some cases that, and I've seen a number of situations, there are some documents that would say the unit owners are responsible for the cost of windows, but the association is responsible to perform the work. In other buildings, it imposes the obligation on the actual owners to do the work and to pay for it. But then you see some cases that say that, to require, let's assume you're talking about a 200-unit building, to require 200 people at one time to hire 200 different contractors and replace windows can also lead to disasters. So there is some legal precedent that gives associations arguably the justification to stand in the shoes of the owners in those cases. And then there are other situations where, for instance, a building has insurance responsibility for windows and glazing, and in the event of an insured loss, it becomes an association's responsibility because it falls under the insurance obligation versus a standard maintenance, repair, and replacement obligation. So there are, again, very mixed opinions depending on what triggers the need to maintain, repair, or replace windows, or what triggered the obligation to have to repair or replace them. And again, I would suggest on a case-specific basis, because it will depend on what your governing documents provide, to reach out to your lawyer if that's the situation you find yourself in.
Great. Excellent. Thank you, Robbie. So I know we did our best to answer. We answered close to 50%, almost 60% of the questions here. We're getting close to that time. We've gone a little bit over. I want to be respectful of all your time. So why don't we wrap up with some closing remarks, and also how our listeners can contact you. There's many questions here. Again, we did our best to put the best of the best together. So I'll start off with Dan, because Dan, I'm sure you've had your hands full after this past weekend. But either way, I know that your firm has helped recover billions of dollars. You've done an amazing job for our clients. So if you'd be so kind to just provide some closing remarks.
Yeah, I kind of stayed away from the D&O issues because we had Robbie on here to take fire for that. But there's, I think it's definitely something a lot of people need to take consideration. But one thing I can say from as an insurance expert is that test drive your product. I think a lot of times we've been, and over the years, we've been so price sensitive. It's expensive, it's expensive, it's expensive. Start to become an expert in insurance and do your own analysis. Ask your brokers for copies of the actual insurance forms and compare them. One endorsement from one to the next may not be the same. Just because your policy has some limitation for wind-driven rain, it may read different than from if you get a proposal from another insurance company. There are multiple different types of endorsements that, while they travel under the same title, the language within them may be different. So do take the time, test drive your product. If you're going through inspections right now, we are more than happy to bring out one of our insurance coverage experts to take a look at the particular issues that you may have with your structure or systems to see if any of those damages that your building has suffered are recoverable in insurance, because there may be a way to recover under property insurance or boiler machinery or various other insurance policies, maybe even a third-party claim, because someone wasn't maintaining something that they were obligated or contracted to maintain for you. So there's many different ways that you can use insurance, but as it relates to transacting and buying insurance, make sure that you're questioning your broker a lot more than ever before, and you're going to market, test drive the products, look at them. If there's several different insurers that are quoting your insurance, take the fancy little spreadsheets and the colorful brochures, set them aside and get into the black and white, the nitty gritty of the actual forms themselves, and demand that you receive actual copies of those policy forms so you can take a look at them, so you can compare and contrast what you're actually buying. I can't tell you how often right now, we're particularly in the surplus lines market where many of you are probably buying insurance, how different the forms are from one insurer to the next. And obviously consider insurance when dealing with these situations. I think the changes and reforms on the inspection side can be used to your advantage, but it can quickly also be used to your disadvantage. So if there's anything else we can do, obviously, to help you. And again, Raphael, and to the rest of the panelists, thank you so much for having us on. We're here to help you as much as we can. This has been an awesome segment. I love the thank yous and the great panel discussion. So more and more coming in.
Thank you, Dan. Appreciate it. Always a pleasure to have you on. And Robbie, if you want to give some closing remarks and how our listeners can reach you.
Yeah, so I may be reached via email. My email is on our website. Our law firm website is siegfriedrivera.com. That is S as in Sam, I-E-G, F as in Frank, R-I-E-D, R-I-V-E-R-A.com. And my email address is rblanche, R-B-L-A-N-C-H, at siegfriedrivera.com. I appreciate all of those who attended and especially those who posted questions. This is hot off the presses. This new law is very, very new. Inevitably, with any new laws that are adopted, there are kinks that need to be worked out. There are questions that remain to be seen as to how they get implemented and adopted and imposed. And very often the legislature has to go back and fix some of the areas that were not fully addressed or may have conflicted with other laws and other regulations or restrictions. So this is not a surprise to me that we don't have all of the answers to all of the questions. I see the big picture here as an objective of our lawmakers to make buildings more safe, to make buildings, building boards, building contractors, engineers, managers, developers, everyone a little more accountable to prevent any tragedies in the future. The reality is in 22 years of doing this, I've never seen a condominium fall the way the tower fell in Surfside. But many people will tell you, one tower is one tower too many. And because of that, you see a lot of these laws being adopted with the objective of buildings being safer. How effective this new law will be is something that is a long-term question, and we're not going to be able to answer it today. Is it perfect? Probably not. But maybe it's better than what we had already in place. So stand by. Let's see what happens in the years to come, and let's see how the legislature responds going forward. So once again, Rafael, to you and to Dan and Misha, for all of your insightful comments and statements with regard to these new laws in the legislative session. Thank you, guys.
Thank you so much, Robbie. Pleasure always to have you on as well. And last but not least, Misha, I know we get the back and forth that there's not enough engineers or whatnot. If you can let our listeners know how they can reach you and your firm, and if there's any closing remarks that you may have.
We're making it very easy. Unlike anybody else, my last name is not in my firm. Thanks God for everybody. Our firm website is m2e.com. It's as easy as that. My email is my nickname, Misha, M-I-S-H-A @m2e.com. Again, super simple. We have a fully functional new business development department that can take care of your request and scope the work. Thank you very much, Rafael, for organizing this. Dan and Robbie, thank you very much for co-attending. It was, I hope, helpful. The famous ounce of prevention versus pound of cure applies here. I know that a lot of the public was disappointed that in the last session, there was actually nothing done as far as moving the needle on the inspections on condos post Champlain Towers. That tragic event embodied something that we as engineers and professionals always talk about and hope that it will never happen. Unfortunately, this tragedy has now put in focus that all of our words were unfortunately accurate, that you cannot let the building unmaintained, like you cannot make your car function with oil or your body on junk food. So painfully reminded of that. I think that what was the impediment that the legislature had to actually pass something promptly the moment that they started working again. I urge you to interview quickly engineers that you believe would be able to help you. We would like it to be us, but there is other capable engineers in the county and in the state that can do the work. Be sure that they have actual experience in this type of building. That's one of the requirements of the new law. So it cannot be somebody who did only renovation of his kitchen and then now wants to do threshold work. There is sufficient engineers if you're willing to wait and fairly compensate. The bottom line is that even if they are trying to come from out of state, which is one of the discussion or ask, they will still need to get their Florida license in order to sign that, and then a special inspector or threshold license on top of that. That's not going to happen quickly. There is enough engineers, there is enough reputable people who can do the work at this point. But if you wait until the 90 days notice before your 30 years, I can assure you that you will not find one or a contractor. Thank you again very much.
No problem. Thank you so much, Misha. I want to thank all of you, as always, for being on the webinar and for saying yes to this panel. It's always an honor and a pleasure to work alongside the three of you. To our board members and managers, thank you for attending. If there's ever a time that you need to work with the strong partners, it's now. As Misha mentioned, as Robbie's mentioned, as Dan mentioned, whoever you decide to go with, just make sure that you're pulling that curtain back and knowing that they understand what's going on. And that's why here at Affinity we focus so much on education, to be able to provide that information to allow you to make the best decision for you and your community. Whether you're a manager or a board member, it's important that you continue to absorb this information because it is going to be challenging times, but at the end of the day, we'll get through it like we get through everything else in life. We apologize, we went a little bit over, but it's a very hot topic. We hope you enjoyed it. Again, we will have this on our YouTube page. It's Affinity Management. If you want to reach us, our website is managed by affinity.com, or you can reach us at 800-977-6279. Thank you all for attending. It's been a pleasure, and I look forward to doing another webinar with you all. Thank you, and
Thank you very
enjoy
much
the rest of
again.
the week.
All the best.
Bye-bye.
Bye-bye.
Thank you.
Bye-bye. Bye-bye.